May I, my lord? I beg to mention item number 21, my lord. The matter may be fixed for 21st August. Yes, my lord. My lord, interim shall we continue?
Hearing list.
I'm for the respondent, your lordship.
Okay. No objection.
I'm for the respondent. I don't have any objection.
Okay. You are Miss
Why Mugli?
Y. Mowgli, Land Council for the petitioner prays for adjournment of the matter and to be listed on
21st August.
21st August, to which Ms. Topi Jin, Land Council, appearing on behalf of the respondent, has no objection. Accordingly, the prayer is allowed. List this matter on 21st.
Secret.
My lord, if I may, I would like to mention item number 6, 7, 8, and 9. Initially, my lord, this matter was supposed to be listed on 5th September 2025, but due to some error, it has been listed today, my lord.
Mr.
Techitopu, my lord.
Land Council for the petitioner.
Petitioner.
Submits that this matter has been wrongly listed. Fixed on?
5th September, my lord,
Okay.
2020. Yes.
Okay. As it was fixed on. This is matter on 5/8. There was a prayer from the petitioner to list this matter on 5 for today only. There is an order. Have you seen the order? Last order?
My lord, I was instructed. I didn't see the order.
Please, please. You should have seen the last order. Wait for some time.
It's obliged.
In this case, my lord, on the last occasion, my lord has given a dictation that this matter to be fixed on 5th September. It was wrongly.
Okay, wrongly listed as 5th August.
Dictated.
Wrongly typed.
Right.
Dictation also for September only.
September only.
But type
As 5th
August.
My lord.
Who typed it? You are for?
I'm on behalf of PD Land for the petition.
Okay. Okay. Submit that. This matter was to be fixed for 5/9/2025. However, in the order dated 28/7/2025, it is wrongly as it is. There is a typographical error written as 5/8/2025 instead of 5/9/2025. So the error in the order dated 28/7/2025 stands corrected. This matter is grateful. Come on, list this matter on 5/9/2025. Okay, grateful.
My lord, I want to mention item number 1920. This matter may be fixed for mediation. We have taken the consent from the other parties.
Wait for some time.
My lord, for mediation.
Your lordship.
After.
That is why it is listed for that purpose only.
Your lordship, I'm appearing for 1 to 5, the state respondent. Your lordship, we have not received the extra copies. Your lordship. Yes, for communication. Your lordship.
Wait for some time. Wait for some time. Okay. You are not praying for adjournment.
Not adjourned. I'm just
Okay.
requesting, my lord, I have just cross examination in session court. Therefore, I want to mention.
Okay, you are for
I'm
for respondent or for appellant?
Appellant, my lord.
Appellant.
Yes, my lord.
Okay, we'll record your And then you have not received?
Extra copies, Your Lordship.
You are for
125, Your Lordship.
1 to 5 in make appeal.
Yes, Your Lordship.
State or the insurance, who?
This is 125. Yes, it's
Okay,
state, Your
this
Lordship.
is
Yes.
against the state.
Yes, Your Lordship.
You have not received the copy.
Yes, extra
You serve the
copies.
copy first.
Yes.
We'll have to communicate this first for instruction, Your Lordship.
The challenge is what regarding?
Regarding my lord, it was dismissed for non-proving of section 279.
Dismissed.
Yes, my lord.
Then why it should be listed for mediation?
My lord, just we have consult.
Wait for some time. Let us see. If it is dismissed,
Yeah.
what purpose it will serve if it is sent even to the mediation also?
It was dismissed only. on
Cannot
the-
restore. Okay,
Then my lord.
wait for some time. Otherwise, you are ready for mediation.
Yes, my lord, I
Okay,
will be.
we'll record your present.
Yes, my lord.
Let me see the order. If you have some work, you can leave and we'll record your presence. Okay,
Yes,
Okay.
yes, just.
wait for some time.
Yeah, yes, Your
Hmm.
Lordship.
Okay.
May I, Lord?
Yeah.
I beg to mention item number 11. Matter may be taken up in next week.
What is this matter about?
Yeah.
Who is for the other side?
Sir, my lord. I for the appellants.
You are for the appellant and you are for?
Respondent.
Okay. No objection.
No objection.
On the prayer of for the learned council appearing on behalf of the appellant and the respondent, let this matter be listed. Next week?
Yeah.
After a week. Okay.
The week.
Hello. Welcome. Then, my lord, I will to mention item number 10. I for the petitioner and I taken the consent from.
10 is with 9.
Yes, it will.
7 to 10. But not the 6. 7, 8, 9, 10. This is connected only. Already adjourned. Okay.
Okay.
6 not adjourned. Huh? Okay.
May I please, madam?
Yes. Yes.
My lord, this is a criminal division, madam. For a year, learned track board has convicted and sentenced the petitioner for 2 years, my lord, under section 304A, and 1 year for under section 25(1)(b)(a) of Arms Act. And hello. Against the conviction, I prepared a appeal before the Lawrence Session Judge 0, and Lawrence Session Judge rejected the appeal. So against that order, I report this honorable court, my lord.
The session judge, what order was passed?
Rejected the appeal.
Rejected the appeal.
Yes. Meaning that this affirmed the sentence of the
Conviction
trial
and
court.
sentence.
Yes, ma'am.
Okay.
So my lord, basically here my ground is that learned trial court, before the learned trial courts, 430(4)(a), rush and negligence is to be proved, my lord. That was never been proved. And the arms, weapons was not seized from the accused, not recovered from the accused. Arms was brought by the PW4, and arm license was in the name of the other person. He was earlier co-accused. He was made co-accused. Then during the CC, he was discharged on the statement of the that person that this arms has been given to the present accused persons, my lord.
Whom discharged?
The owner of the weapons, my lord.
Okay.
So, my lord, during the trial,
Whether the owner
he was not
was
even,
made a
even,
prosecution witness,
no, my lord.
Not examined.
Not examined.
so he was discharged at the time of framing of charge.
Charges, my lord.
Okay.
And my lord,
What record was shown that the arm was given to the accused by the owner?
no any, my lord. In the CC, it is reflected that that person owners was discharged,
Owner was having a license.
License.
Valid license.
license. Even license was produced, seized, but owner was not examined. Seizure witness was not examined even, my lord.
Okay.
So therefore, arms X will go, my lord, if that is not proved. And in respect of 304A, my lord, the London Trial Court as well as the Appellate Court have you rely on the statement of the PW5, who is the IO, my lord, and PW4.
Who
And-
is PW4?
PW4 is the witness who was also present at the sport, my lord, at jungle, my lord,
At the time of incident.
incidents, my lord. And before PW4, the big accused made a extrajudicial confession, my lord.
PW4 is IO.
Not IO, my lord. He is the PW4 who was present at the jungle, my lord. IO is the PW5.
Whether the PW4 was eyewitness to the incident.
No, not
Okay,
eyewitness.
so the accused made a extrajudicial confession before PW4.
4. And extrajudicial, if that extrajudicial confession as well as 313 and that extrajudicial confession has been heavily relied by the London Trial Court as well as the Appellate Court, my lord. And
Whether in the 3-on-3, the accused denied having given an extrajudicial confession.
no, my
before
lord,
the-
that was not denied,
Not denied.
not denied, my lord.
He admitted.
Admitted. But rash and negligence, even rash and whether that incident was caused by the rash and negligence, even that question was not put to the accused person, even in 313, my lord. And for conviction under
What explanation the accused person had given?
accused says when he moved for the jungles, he saw like an animal, my lord. Animal. Then he shoot. Then later on is found that
He gave this statement before in his examination under 313.
yes, man.
Okay. So the court relied on this.
Yes, my lord. Then my lord, for 304A,
Whether have you given any statement or confessional statement before the magistrate?
no, man.
Okay, but then you have reiterated your police statement.
Yes, man.
Okay, then what is your objection? You yourself has admitted?
If that's 313 as well as the extrajudicial confession before the
Because you have reiterated, what? There is no reason to disbelieve your statement if you have reiterated the same statement which the witnesses
Exactly.
have given.
therefore I'm saying, my lord, if that statement is taken to be considered,
Hmm.
section 79 will come into play, my lord.
Hmm.
That's mistake of fact, my lord.
So that is why it is 304 only.
No, 304, for 304 to attract to bring the accused person under 304, rash and negligence is to be proved, my lord. What that rash and negligence question is even not put in materials, my lord.
So what is it, then what according to you should be under the circumstances, under fact and circumstances of the case? Because if you say that because of it was a mistake of identity.
Yes.
So what according to you should be?
But he should be acquitted, my lord, because to bring the accused persons under 304A, the prosecution has
What
to
has to
prove
prove?
beyond reasonable doubt, my lord. Beyond reasonable doubt. Though they are basically basing on the circumstances, my lord. Those circumstances is broken when the arms was not brought before the courts, and even FSL report is there, but they have not proved the FL reports also. And appellate reports also not support the prosecutions, my lord.
The serviceable of the guns were not proved. No, no FS report.
Appellate report is there, but they have not proved the FLC report, my lord.
Okay, okay. The person who gave the report. he
Ye-
did not
Yes,
turn up
yes, my lord.
To give, okay.
Yes, my lord. So at this stage, my lord, let the notice be go and
Issue notice?
IA.
Yes,
Yes, your lordship.
anything?
No, not at this stage, your lordship, but then with regard to the IA, your lordship, since there.
Well, where he is now at the moment? Taken into custody?
No, no, my lord.
Not
Because,
yet. Then I think,
Yes, my lord. Throughout
that-
trial as well as in appeal, my lord, he was in, my lord. Because he was in custody for 6 months and 17 days, my lord, before filing of charges, my lord. I have furnished, annexed the,
hard Mr. K. Tari, Land Council for the appellant. So criminal revision petition, sorry,
yes, no.
petition. Start. The, is the person, the accused, or the convict himself? Is the petitioner?
Yes.
The convict himself?
Yes, no.
Okay, the petitioner. File this revision petition. Under section 438. Read with section 442 of the Bharatiya Nagrik Suraksha Sanhita, within brackets, the hereinafter. No, we are in after. On BNSS 2023, huh? Challenging. The. We have said order. Judgment, it's a judgment and conviction.
Yes, my lord. On same day, only sentencing order is to be stayed, my lord.
This, which one is sentence order?
My lord-
19,
My lord, is on IA, my lord.
okay. The,
7/3/2024.
no, just a minute.
Same judgment and sentencing order is same date, my lord. In IA 47, page
Just-
47.
just- Judgment. And conviction.
In criminal revision petition, page 56. 56. 53.
Okay. Challenged, judgment and order of conviction and sentenced. Passed on 7/3/2024. In GR case number 19/2020. Just a minute. Within bracket, KLG,
Colonial.
PS case number 14/2020 bracket close under section 304. Within bracket capital A of IPC, read with section 25. Within bracket 1 capital B bracket close. Within bracket small a bracket close Arms Act. And criminal appeal number 01. Just a minute, huh? Is you have challenged the criminal appeal also?
Yes,
sir.
Order, okay. Whereby where is the sentence order?
sentence order is 53 page, my lord.
Page?
53. And appeal
Just a minute, where-
appeal order is, my lord, dismissal order is page 17, my lord.
just a minute. The petitioner to convict has been sentenced to undergo simple imprisonment for a period of 2 years for offense under section 304A IPC. Simple imprisonment for a period of 1 year and a fine of rupees 10,000 with default clause. So the petitioner has also challenged where is the criminal appeal order?
Page 17, my lord.
70.
17, my lord. Plenary resolution. Judgment dated 19th May 2025.
Hmm. Order passed by the first appellate court on 19/5/2025 in where is the number criminal appeal number 01/2020/2024 within bracket Z. This notice. Call for the trial court record. Who else are the parties?
Only statement.
Only state.
Yes, ma'am.
Okay.
Your Lordship,
Miss.
Your Lordship, if Lordship take into account Jagjit Singh's case, Your Lordship.
Hmm?
If Your Lordship take account Jagjit Singh's case, Your Lordship. The
Case?
Jagjit Singh's case passed by the apex court, Your Lordship, where the parties it mandates that the complainant or the informant be made a party, Your Lordship.
So that is applicable in such cases. also.
Yes, Your Lordship. It does not distinguish any particular case, but overall cases.
But my lord, our High Court have also notifications.
Hmm?
In this, our High Court has also notifications. In 301 case, such case, it is not required, my lord.
Where is, can you just see the notification?
Just no, I am bringing only for
Normally it is expected that the informant should be made a party. Who is the informant out of this? Yeah?
He's the elder brother of the
Yeah.
deceased.
I think it is safer always. to
even
make
my lord,
party.
in appeal,
Hmm.
I was made him as a party.
He was made a party.
Appeal made, but he was struck down, my lord. The is not necessary party, my lord. Even he was not afeared, my lord, despite the receipt of the
Maybe he might not appear.
Yes.
He might not appear. That is why to ensure that justice has been done, you have to, I think, make necessary party.
Otherwise, he is not necessary party, my lord.
Hmm. Okay, Miss Jimmy, I am addition PP. Accept notice on behalf of the state. And pointed out that the informant need to be made, informant being a necessary party need to be included in the present criminal revision. Okay. The petitioner said complete the informant as respondent number 2 by filing amended post-statute and post-statute, huh? Okay. Since Ms. Jeannie accepted notice on behalf of the state respondent, no formal notice need be issued. So, the petitioner shall take steps upon after implement, the petitioner shall take steps upon the respondent informant. Okay. You complete first, then thereafter, and passing over to take a step subsequent.
Yes.
Okay. By filing amendment petition within a week from today. Okay.
Yes.
And thereafter take steps up on the respondent respondent by a registered post with AD as well as by usual process. within another 1 week. Okay,
Okay.
release this matter after 4 weeks.
Matter IA.
Mhm. Then the petitioner has also filed an IA number 534. It's a 534.
Yes.
Rainfall stay of the okay, separately pass order then.
IA 79, my lord.
Okay, IA 79, Mr. Swain, same, okay, and also Ms. JD, and ADP for the state. In the appeal will be admitted, Ms. JD, appeal will be admitted, the second paragraph in the, sorry, criminal revision will be admitted, by filing this application,
Your Lordship, it's a revision, revision may be admitted.
okay, leave that, no? By filing this application, the petitioner prays for suspension, stroke, stay of the sentence of the judgment in order dated 7/3/2024, passed by the Lana Judicial Magistrate First Class, Kurunku Magistrate, and judgment in order dated 19/5/2025, passed by the session.
That, my lord.
Why that is necessary?
That may be not, my lord.
That is not necessary.
Not necessary, yes.
Here, that is enough. 7/3. 7/3 is the judgment and sentence order.
Yes, yes.
Okay, pass in GR case number. Same what has been given in the revision, okay? GR case numbers 1920, stroke 2020. In Colorium PS case number 14/2020 under section 304. And sentencing, all those same repeat, whereby the convict has been, where the accused has been convicted and sentenced to undergo simple imprisonment for 2 years under IPC. Under 30 IPC, and simple imprisonment for 1 year with fine of rupees 10,000 under section 25 of under section 25 within bracket 1B bracket close within bracket small a of the Arms Act with default clauses. Issue notice. Same, returnable by 4 weeks. Stuff in the meantime, the operation of the judgment, operation of the same, the judgment and order dated so and so. 7/3/2024 passed by the Lana Judicial Magistrate First Class shall remain stage till the next returnable date.
Your Lordship can dispose this IA, since Your Lordship will suspend the order, Your Lordship. Because he is not in the jail, Your Lordship, at present, Your Lordship. In that case,
It is submitted that the next pair, it is submitted that the convict petitioner has not been arrested. Has not yet been taken into custody. So After application, okay. The, considering the, considering the ground taken and ground taken by the petitioner, and also considering that he has not yet been taken into custody, the prayer is allowed. Accordingly, the judgment and order dated 7/3/2024, passed by the non-judicial magistrate first class, Orunkamea district, in criminal, in GR case number, same, CF case number 19/2020, in Colonial PS case number, same, cell, remain stayed till the it will be till the conclusion of trial,
Yes.
conclusion of till the conclusion of the revision petition. Revision petition. Yeah. So with the above this, IO stands dispose of that.
I would like,
In that case, also one sentence to be reflected.
Yes, Your Lordship, with regard to IAL.
Mhm.
Deeply.
deeply obliged.
This criminal petition is for quashing.
Okay. Okay, same advocate, okay.
This petition is for quashing of the FIR and the subsequent charge sheet, my lord, solely on the basis of the settlement. My lord may kindly have page number 16 for a time. 16. The type copy is at page number 19. Mary. With due respect and humble submission, I would
Yeah,
like
just a
to.
minute, just a minute. Okay, so this is passing petition,
My lord,
yes, FIR.
FIR, my lord, page number 19 is the type copy. my lord.
Yes,
Subject so and so, sir. With your respect and humble submission, I would like to state that my house has been looted by some unknown person at around 12:30 PM at so and so, 24/2022,
Hmm.
and had stolen 2 mobile phones, so and so, so and so. Therefore, I'll be grateful and thankful to you to take all necessary action, please. And basing on this FIR, my lord, the criminal law machinery was set into motion. And after completion of the investigation, my lord, this has been culminated into charge sheet. If my lord may have page number 22, my lord, that is the charge sheet.
page
Page 22,
relevant would be 25.
my lord. Last part, my lord.
Yes,
Hence, prima facie case under section 454/380 IPC is well established against accused so and so.
what is
24
452?
My lord,
What is 452?
454 is lurking house trespass or house breaking, my lord,
Okay,
and 380
Okay,
is theft in a dwelling house. Therefore, I am sending the arrested accused person Kodarana to the honorable court stand trial under F law. The honorable court is prayed to summon the witness mentioned in column number 13 after fixing date and the time of the trial to prove the case. Now, thereafter, my lord, the matter is at the stage of appearance. And while filing, before filing this charge sheet, my lord, the
Court has taken
complainant,
cognizance of,
my lord,
he should summon also.
someone has been issued, my lord, cognizance has been taken. Trial is yet to start,
Charge not yet framed.
not yet start.
Okay,
And in the meantime, my lord, before filing of the charge sheet, the complainant has passed away in the year 2022. If my lord
Okay.
may have page number 36 for a time being.
this was way back in which year the complaint was lodged? 22,
22, my lord.
and the informant passed away?
Passed away on 24/8/2023, my lord.
Okay, 23, next year.
23, my lord.
Okay.
Page number 36 is the death certificate.
Okay,
Thereafter, my lord, the agreement has been executed between the wife of the complainant and the accused
okay.
by mutually agreeing by both the parties to resolve the issue once and for all.
It was a stealing of, what was the article?
Two mobile phones, my lord,
Whether
two
that was recovered,
recovered and returned back,
handed over to the.
hand over to the complainant.
Okay. So now. During his lifetime. Okay, it was not yet filed not yet filed. The case, filed the case into charge sheet. So now, charge sheet was filed after the, expiry of the informant.
Before the expiry, my lord,
Okay, before that,
before
okay. The settlement was only after.
before the expiry. Charge sheet was filed in the year 2022. And the-
Whether any other incriminating, if the witnesses had said something which is.
nothing, my lord. No witnesses as such who
No
has
witnesses
seen
as
the occurrence, my lord.
Okay,
Only on respect of two mobile phones had been recovered and returned back.
yes, what do you say?
Lordship, since it has already been recovered and also the complainant is not already expired, your lordship, I don't have any objection for questioning of
Can we
this.
dispose of?
Yes, because even otherwise, my only concern was since the charge sheet was also of the year 2022. However, since the complainant himself has expired, your lordship, and therefore,
No, no one
as,
proved.
yes, so
Okay. Hard, mister. Yes, you do. Learned counsel for the petitioner. I have also heard Ms. Eugenie, learned additional people for the state respondent. So I'll pass order.
Great.
deeply oppressed.
Just a minute, huh? Mr. Siri, just a minute, huh? What is the GR case? GR, have you mentioned? Where have you mentioned the GRK? Okay, so it is at what stage you said?
At the stage of appearance, my lord.
Okay, just a minute, I'll take one sentence, huh? This is. This is a joint petition filed by the petitioner. For passing of the criminal proceeding. GR case number 296/2022. Arising out of Papu Hill Police Station case number 17/2022. Registered under section 454/380 of the Indian Penal Code. Pending before the court of which court?
Chief Judicial Magistrate, UPM.
The Chief Judicial Magistrate, UPR. Okay. Just a minute, sir. Lest I forget. The petitioner number. It is submitted that the informant in the above case has passed away on
24/8/2023.
24/8/2023.
23. Annexure 4.
Okay, the death certificate of the petitioner has annexed the death certificate of the informant as annexure 4. The informant is being represented by his wife. The informant. What was the name of the informant?
Informant, my lord,
Kinaram Diori.
Tanuram.
Kinaram.
Kinaram, okay. Kinaram Deori. Or Kinaram Deori. Within bracket, since this is bracket close, he is being represented by his wife, Srimati Injuna Deori. who is the petitioner number 1 in the present petition, and the petitioner number 2, Sri Khodarana, is accused in the aforesaid police station case. It is submitted that after investigation, after completion of investigation, the police has submitted the case in the charge sheet against the accused, petitioner number 2, for offense under section 454/380 IPC. The Lane Court of Chief Judicial Magistrates has taken cognizance of and issued process against the accused person. But however, in the meantime, the case has been amicably settled between the parties by executing a deed of amicable settlement
31/7/2025.
on 31/7/2025, wherein it is reflected that immediately after the lodging of FIR, the stolen article named 2 mobile handsets has was recovered and handed over to the informant, and that since the informant is no more since deceased, no more within bracket since deceased, the petitioner, who is the wife of the informant, has clearly stated that she, on behalf of her deceased husband, do not want to, does not have any or does not have grievances, does not have any grievances against the accused petitioner. And since the matter has amicably been settled, she don't want to pursue with the case before the court. Miss Jeannie, Lane additional PP, clearly submitted that since the stolen article was recovered, stolen article, that is 2 mobile handsets were recovered immediately after lodging of the FIR from the accused, and the same was handed over back to the informant. And in the meantime, the informant also passed away, and there is no one to prove the prosecution case. So further, the matter has been amicably settled between the wife of the deceased, wife of the informant, since this informant, since within bracket since deceased, and the accused persons, where the aggrieved within bracket wife of the informant has clearly stated that she has no further grievances against the accused persons, and she does not want to pursue with the matter, pursue with the case any further. In view of the above, she has, in view of the above, as there is no chance of, as there is a bleak chance of conviction, she has no objection if the prayer of the petitioner is allowed. I've heard both the Lane counsel for the parties. Okay, I'll conclude.
Before
Yes.
May plus one. My lord, this is criminal joint.
Criminal petition.
Yes, criminal petition. Jointly filed by the complainant and alleged accused person as a petition number 1 and 2 for setting aside FIR dated 14/10/24 by the Papu Hill PS case number 733/24. My lord, initially this was registered under 774/118 plus 1 126/1.
What is this 74?
It's for assault or use of criminal force to women with intention to outrage her modesty, Your Honor.
What is
My lord.
what is 115?
And regarding 118 is for voluntary causing hurt or grievous hurt, but
115?
initially it was registered, but after investigation, completion of investigation, this was replaced by 115 close to. So voluntary causing hurt.
So what is 126? 126,
126. It's for wrongful restraint. And regarding 35 is for common intention.
Okay.
So out of this, only this 124 is the non-compoundable section.
74 is
Yes,
non-comparable?
yes, it's non-compoundable. Rest is compoundable. And back of the cases, FIR, may I take my lord to FIR, page number 13. This is the allegation, may I? To the officer so and so, a complaint against Yanga Mara to attempt to murder. Respected sir, with due respect and most among submission, I would like to inform you that today at around 9:30 p.m., while I was normally working with my old friend Mr. Subhas Nidak at railway station Narlagan, suddenly Mrs. Yanga Mara and her group, male and female total 10, attacked me with iron rod on my head and using chili powder in my eyes. While fighting, they also took videos. They also attempt to kill me, but I escaped. So this is the allegation, my lord. The fact of the case is, my lord,
Charge sheet,
On-
charge sheet file. What is the status of the case?
status is it's
After charge sheet file, whether
only charge sheet file.
process
Process is not yet started. Trial is not yet started. Yes,
the court has not yet taken cognizance.
yes,
Not registered as, not yet registered.
yes. Not GR number is not here.
No. Once the case has been charge sheeted before the court,
I think it has been already take cognizance, Your Honor, because my lord, because it has been already endorsed to learned CGM. Oh, sorry, learned JMFC.
JMFC, then it
Yes,
must
by
be-
the-
then you
the
have to
let's see.
find out. That should be your impugn challenge order.
Yes. Now, since the fact is that, my lord, on 14/10/24, petitioner number 2, who is the accused in this case, alleged accused, she meet her husband at railway station along with petitioner number 1 at around 11 p.m. The petitioner number 2 asked the petitioner why she was with her husband late at night, but before petitioner number 1 could respond, the husband of petitioner number 2 intervened, which led to the incident in question, my lord. And now the parties have already settled their dispute and
Okay, yes.
they have executed.
Yes, my lord, I have an objection on the very maintainability of this case. Why? Because, your lordship, they have come with a piecemeal settlement, my lord. Not all the parties have entered into an agreement. There are total number of 4 accused, out of which only one has entered into an agreement with the complainant. And your lordship, recently, your lordship, the division bench of the Punjab and Haryana High Court, your lordship, which has, there it was, all this aspect has been discussed, that on piecemeal basis, the case cannot be quashed. And it was further held that the victim cannot act as a driver of the prosecution. my
That
lord.
means total 4 accused persons.
Yes, my lord. 4 accused person has been charge sheeted. my
And
lord.
then this agreement, settlement agreement. what
Only
is it?
complainant and one of the accused, my lord.
Then you are praying for this quashing and setting aside of the entire case. That will be
yes, sir.
difficult. That will be difficult.
They all have to come together, my lord.
That will be difficult. Then in that case, you have to pray in respect of the present accused applicant.
That is also not permissible, my lord. I will
No,
come with
even,
that.
even if he has to pray.
Yes, your
Because if
lordship.
he's agreed and if he's not
If he's so,
concerned with the other.
only that is why, your lordship, I have submitted that
If he says
the
that
accused,
nothing
the,
has been
my
said,
lord, it has been held that the victim cannot act as a driver of the prosecution.
Hmm.
He cannot pick and choose that, okay, I will
Right.
settle with you and I will go
No.
for quashing only on respect of this accused.
Now-
No, your lordship.
Now, my lord, in that case, my lord, I may be allowed to withdraw and
Yes,
liberty may be given.
Better, because you have not
Since-
given the GR number also. You
Yes.
say that it is already been charge sheeted, taking cognizance, already made over to the judicial
But-
magistrate
but
first class.
in
What
charge sheet-
need to be?
In charge sheet, there's no GR number is not given, my lord.
Charge sheet, it
Therefore-
cannot be.
Yes.
Once it is going, it is.
Here is
received
for
in the
court number,
then
court case,
nobody.
court number, for court.
It is the duty of the court to number it. So you better withdraw and then come again with the settlement with all.
All the parties.
And then, and also collect the information from the court, what is the GR number and what is the latest status of the Mr. Geetadi, Nana counsel for the petitioner wants to withdraw this criminal petition with liberty to file afresh after making necessary correction. To which Mr. P.A.T. Nana Edison PP, there's no objection, stop. This criminal petition stands dismissed on being withdrawn with liberty as prayed for.
Yes, sir.
Obliged, obliged.
Your Lordship, may I submit? Your Lordship, this petition is filed under 528 of the BNSS for quashing of the order dated 30/07/2025, passed by the EAC Itanagar.
You are praying for setting as a quashing of the order.
Yes, Your Lordship.
This was passed by,
EAC Itanagar, order dated 30/07/2025,
okay, where is that?
which is in page number 16.
No, what it says,
Srimati Bhat Yadang.
this is proceeding under what?
It is it is not mentioned under which provision it is, this proceeding has taken place, but the EAC has invoked the provision of the Protection of Women from Domestic Violence, 2005.
Domestic violence.
Yes, Domestic Violence Act. So basically, it has been, that provision has been invoked.
Okay. So, who is the informant?
The, no, that, you know, this is, the issue in this case is a bit different.
Okay, this is on merit.
Yes.
Okay, not the. Who knows complaint before the
It is the respondent, that is.
respondent number 4?
Yes.
Respondent number 4 is wife of?
Wife, she is wife of one person called,
No,
The-
not the wife of the petitioner.
no,
Domestic violence against whom?
she is claiming that she is being evicted illegally.
Hmm?
She is claiming that she is being evicted illegally by the petitioner hearing, that is Pasang Nia.
She was treated illegally or what?
Your Honor,
Beaten.
I'll take your lordship to the main case.
Okay,
What happened in this case, Your Lordship, is that the petitioner herein, the Pasang Nia, he is the owner of the plot of land at Gopur Tinyali, Gopur Itanagar. So this Pasang Nia, he bought a plot of land from one person called Likha Tat, who is the elder brother-in-law of the respondent number 4, that is Bat Yarang. By the sale deed dated 18/6/2025. The petition here, he bought the land from one Likha Tat, who is
okay, is there any complaint? Or is there any complaint or anything based on which this EAC has passed?
yes.
Where is that complaint?
The complaint copy we don't have, but we have annexed the summon.
Hmm?
The complaint copy we don't have, but
No,
we have
well,
annexed the
we
summon
would
of
like
the,
to see the content of the complaint. Where is the complaint?
that Your Lordship we don't have, but the summon we have annexed the summon. The summon issued to us by the.
No. Someone? No, no, what I'm saying is you are agreed by the order passed by this executive magistrate,
Yes,
EAC.
yes, Your Lordship.
Okay. My query is, where is the complaint based on which this EAC has passed order? Where is that complaint letter?
That complaint that we don't have, Your Lordship, because we have applied for that complaint copy.
That is necessary, that is necessary.
But Your Lordship,
Otherwise, how would we know that whether this order is correct, rightly passed or wrongly passed?
Your Lordship, a look at the summon and the order, that will make this clear, Your Lordship. If we peruse the summon copy,
What is the difficulty in annexing the
Your
complaint?
Lordship, that we don't have.
Compla-
The difficulty is that copy we don't have, because it has not been provided
Because
to
you
us.
were summoned by the EAC,
Yes, Your Lordship.
you did not obtain the complaint against you.
We have prayed for that complaint copy, but we are not issued, Your Lordship.
Now, how you are aggrieved?
By this EAC order, because by this order, the EAC.
No, well, you must have appeared before the EAC.
Yes. We appeared.
EAC did not give any opportunity
Yes, everything is in record, Your
to
Lordship.
you.
Yes, we appeared before the EAC. We placed our written statement also, which is also in the record in this petition.
So where is the application that you ask, you seek or sought for the copy of the complaint against you from the EAC?
That also we don't have, because we have applied for the application, but then we are not provided the complaint copy.
See, on assumption or presumption, it will be very difficult to understand.
Yes, Your Lordship, but if we look at the order copy, Your Lordship, the order dated 30/07/2020.
Order is there, that's why whether the order has rightly been passed or not is to be assessed from the complaint only. What is the complaint and what is the order? The court need to see.
Your Lordship, kindly look at the summon.
You are agreed by this order only,
Yes, Your Lordship.
not by the complaint.
No, by this order. Your Lordship.
Complaint was not against you.
No, complaint was actually not against me. Technically, it was not supposed to be against me. It was supposed to be against her husband.
No, see, what the summon says,
That is in page number 30, Your Lordship.
30,
Yes.
yes.
Whereas a complaint has been received by the undersigned from Srimati Bat Yadang, wife of Sri Likha Thakur, Gopur Tinali, Itanagar, regarding illegal eviction and occupation of our house by Sri Pasang Naik. So although my name is mentioned here, but it was supposed to be against her husband, because I purchased.
Pasang is a
I am the
present
petitioner.
petitioner.
Yes, and I am the owner of the land.
Okay, let us see the impugn order.
That is in page number 16, Your Lordship. Page 16, Your Lordship.
He has stated so many things. You have logs, hereafter the mail was customary court, that was also there, hearing was also done. Who is the Likhataku? Who is Likhataku?
Likhataku is the,
Between her and her husband.
Likhataku is the,
So many
yes,
allegations, see? Her and her husband. Likhataku.
Likhataku is the husband of
No,
the respondent
so-
number 4.
In the court, the assumption and presumption, we cannot be.
Your
Based
Lordship,
on that, we cannot pass order.
Your Lordship, I'll clarify the thing.
Your verbal submission out of
If we look at the written
instruction
statement,
will not do.
yes, Your
It has
Lordship.
to be based on the record only.
Your Lordship, if we look at the written statement of the,
Started the peer work claiming, so many complaints, I think. The gift deed, she talk of the gift deed also, so and so, the khata. You have executed. You are Pasanai,
and Pasanai.
and who is this Likhatat?
Likhatat is the,
See, another person, we,
Brother-
no, so
brother
many
in-
names are coming here, appearing.
Likhatat is the brother-in-law of the
Likhatat-
respondent number 4.
Likhataku is also appearing, there is only.
Your Lordship, there are, here in this case, there are only 3 persons are important here. The first one is the respondent herself, which is the Pat Yadang. And second is the Likhatat, who is the elder brother-in-law of the complainant, Pat Yadang. And third is the Likhataku, who is the husband of the respondent number 4. So Your Lordship, in this case, is the petitioner hearing, that is Pasang Nai, he bought the plot of land at Goput Inali from Likhatat, who is the elder brother-in-law of the
How many parties, respondent parties are there?
only one, Your Lordship. I mean, no,
There
not
are
only
so
one,
many
respondent, no.
There are so many names in the.
Four,
order.
4.
And then the respondent is still the wife of one Mr. So and so, so many things. Do you, don't you think that some of these are a necessary party?
No, because Your Lordship, this order has been passed only against me, only against Pasang Nai, not against other party. Although the dispute is happening between the respondent number 4 and her husband, that is Likhataku, but this order has been passed only against me.
Is it like was there this domestic violence case also?
One case is pending between the respondent number 4 and husband in the customary court before the Kamura Yazali. So during the pendency, she filed this complaint, which is also not in fact maintainable during the and in fact, Your Lordship, my case is quite different from the dispute between the husband and wife relationship.
Domestic violence case is against you.
No. Because Your Lordship, I'm not her husband. I am the owner of the land which has been sold to me by,
See, then this order itself says the Deputy Director ICDS UPR Protection Officer is requested
Yes, yes.
to intervene and extend all help to the respondent
that,
as
that,
per the protection.
that is the illegality, Your Lordship.
Hmm?
That is the illegality.
And then she is still the wife of somebody.
She is the wife of,
That indicates that you are disturbing.
now the land has been sold to me by her husband, her brother-in-law. Her husband gifted the land to his elder brother, and the elder brother sold the land to me. That is the case here. Now you'll see the illegality here is that the
EAC of which place?
Itanagar, ICR.
I think there is some complications which you need to clarify. Yes. Will issue notice?
Yes, Your Lordship. Since the complaint letter of the complaint of the private respondent has not been annexed, Your Lordship,
Mhm.
we have to ascertain under what basis the This order has been passed. Your Worship.
We'll call for the record.
Yes, Your Worship.
Otherwise, in the meantime, you also find out.
Your Worship, the record may be called for because we approached.
Heard Mr. K. Thaja, Land Council for the petitioner. By filing this application under section 528 of the Bharatiya Nagrik Suraksha Sanhita, the petitioner challenges the order dated 37
Yes,
30/07/2025 passed by the extra assistant commissioner come executive magistrate Lanet, extra assistant commissioner by executive magistrate Itanagar in connection with the complaint case number 00/2025 This is 00. What is this 00 number? How can this be the number? Is it
page number 16, Your Worship.
page 16?
Yeah, that is the.
Where do we find that
E-
00
E-
number?
No, that number is EAC. That is the case number.
Now, why you have written this 00? Case number. Then pass in extra assistant executive come executive magistrate in number EAC.ITA/JUD-05/2025. Within bracket Srimati Bath BAATH Yaden YADENG versus Sri Pasang Nia alias Nai NIA alias NAI Nai. What is the ground of challenge?
The ground of challenge is here, Your Lordship, that the EAC Itanagar has no power to invoke the power of the Domestic Violence Act. Because if we go by the Domestic Violence Act, then magistrate means the judicial magistrate of the first class.
On the ground that the learned EAC come have power under Domestic Violence Act to pass such order.
Yes, Your Lordship.
Staff on para issue notice. Call for the record from. Call for the relevant record, staff. Who appears? Who appears for the state?
Lordship, I'm for one lordship.
Okay, they are different. Okay, Miss L. Hage, Learned Additional PP appear and accepts notice on behalf of the state respondent number 1 and Miss Sangeeta for
2 and 3, Your Worship.
respondent number 2 and 3. No formal notice need be issued to the said respondents. However, the petitioner shall furnish requisite extra copies to the Learned Council, the Learned State Councils during the course of the days. Staff on para. The petitioner shall take steps upon the respondent number 4, upon the private respondent number 4, by a registered post with AD as well as by usual process within a week from today. Staff, this matter after 4 weeks.
Your Lordship, that my interim prayer may be granted. Kindly this order may be stayed for some time because Your Lordship, I'm being pressurized very highly by the police to remove
No,
my,
what is the direction?
that
what is the direction which, according to you, will
Did the-
adversely affect?
Page
the-
17, Your Lordship.
Hmm?
Page 17.
Which one? OCPS is directed to provide and ensure safety and security. Safety and security, what's the problem? You don't want,
There is
you want to
nothing
attack
against
or
him.
what? Huh?
There is nothing against him, petitioner.
Nothing against you.
There is
So that
no-
means safety and security, the EAC is providing safety and security to the respondent.
Point
You,
B.
you have objection.
Point B, Your Lordship. Point B, actually.
Hmm?
Point B.
B.
Yes.
What is B?
Page 16.
Is immediately directed to remove all locks, not yet removed.
Because Your Lordship, I have been taking this renovation activities.
Hmm?
And I have been taking renovation activities in my
No,
house.
let them appear.
Lordship, then status quo may be imposed, Lordship.
It is Your Lordship, the
Locks.
order of status
Because
committee.
Lordship, as per the Lordship, this order, Lordship, it is rightly pointed out that the executive magistrate
Because-
cannot pass any order regarding the domestic DB Act, Lordship.
Locks.
It is in this
Because Your
regard,
Lordship,
order
if
is
no
not.
order of this status quo is granted to me, then I'm being pressured very highly by the police. So at
You
least
have not yet removed the locks and obstruction from the residence of the respondent.
Because Your Lordship, that is my house actually, which I have bought by paying 80 lakhs.
And then you have also been asked not to indulge in such illegal activities.
That is a dispute.
So
Your Lordship.
how do this court allow you to continue with the
Now, Your Lordship,
illegal
under-
activities?
Your Lordship, under such circumstances, the maximum the EAC could have done is to invoke the provision of 145 CRPC and to order for maintenance of peace between the parties. But what he did is,
Even if he pass status quo order also, he will continue with illegal activities.
No,
no, that I will not, Your Lordship.
that is, Lordship, further we can, no criminal activity be done, and status quo should be done by Lordship, because this order, Lordship, as your Lordship knows this, Lordship, that executive magistrate cannot pass any order regarding DB Act, Lordship.
Having heard the parties, it is provided that in the interim, a status quo over the status quo as on day shall be maintained by the parties. With regards to the property in dispute.
Yes.
With regards to the property in question. Okay. List this matter after 4 weeks. Okay.
Give you very much.
My lord,
Yes.
this is, my lord, the petition jointly filed by the complainant, victim and alleged accused person on the mutual settlement, my lord. My lord, the brief fact, my lord, will see on 28 June, my lord, this complainant, my lord, who is the petition number 1, was engaged and hired by the petition number 2 for carrying out the building construction at Lower Empty Village, my lord. In the evening time, my lord, on fateful day of 28 June 2025, my lord, in the evening time, they sought for the petition number 1, sought for leaving early from the work site without finishing a small portion of the work, my lord. On this account, there was a petition number 2 requested the petitioner 1 to complete that said small pending works, but that was not done. Accordingly, there was a heated exchange of the words, my lord, during which the petition number 2 allegedly used filthy and unparliamentary word against the petitioner, my lord. And there was on the basis of this, my lord, there was a scuffling, and both petitioner that fall down on the ground at workplace, my lord, and the petition number 1 has sustained injury on his left hand, my lord. On the basis of this, my lord, this FIR, my lord, was lodged. FIR at 16, my lord. FIR registered on
Yes, FIR at page.
age 16, my lord, 16. Doimuk PS case number 87 of 2025 under section 118 subsection 2 of BNS, my lord, it was registered, my lord. That is voluntary causing grievous harm, my lord. It's correspond to the 326 of the IPC, my lord. So it's non-compoundable offense, my lord.
What is 320?
326 corresponding, it is not, my lord, in the
Okay.
BNSS, my lord, it's
1182 is 326.
Yes, it
It's
is
not-
correspondence to
non-compa- that is-
326 in IPC, man. It's
Non-compa-
non-compoundable offense, my
Yes.
lord.
So
So after registration, man, this both party enter into the settlement agreement at 19, man, page 19, my lord. That their all dispute and difference has been resolved, man, amicably.
what happened? What is the status of the case?
My lord,
Status of the case?
my lord, it is under investigation only, my lord.
Investigation only.
Uh,
And how do we?
My lord, since section part only section, my lord, or 112, my lord, 118 of
No, that is what I'm saying.
Yes.
Case is still under investigation. How do we interfere with the investigation of the case?
my lord, that's why, my lord,
This
this
appears
FIR
that-
for
this
question of
appears
the FIR only, my lord.
And then your bail was also, it appears, rejected.
My lord,
Rejected or
bail was
granted?
granted, my bail granted, my
Bail
lord.
was granted.
Yes, my lord.
How long you were inside?
My lord, the AV, my lord, on anticipatory bail, my
Is
lord.
it AV?
Yes, my lord.
And then the informant is a labor.
Yes, my lord.
He-
From missing community, my lord.
It's difficult.
Page 19, my lord.
Difficult. 326.
326.
Need to, I think record need to be called for. No? We'll have to see.
My lord,
326. And then he's a labor class.
my lord,
We have
that,
assorted. And then it appears, of course, there is a agreement.
my lord, that is, my lord, there, my lord. My lord, only my responsible
But
commission,
in
my
all
lord.
the cases, it's difficult. The case is still under investigation.
My lord, since the both party have they have resolved it.
Maybe. But then you see the status of the parties. One is labor, you has assorted and then registered under 326 IPC, grievous
Minor.
injury. And then thereafter you have settled. It indicates something else.
My lord.
So in all the cases, if the case is still under active investigation.
My lord, that part is there, my lord, but the 326, my lord, the 326, my lord, even it is, even in case of conviction also, my lord, Honorable Supreme Court must allow to settle, my lord.
70, huh?
And just recently in 2000,
That is why
January,
record needs to be called.
my
We
lord,
call for the record.
my lord,
Okay, we'll see the record.
my lord,
Okay, and then the case is still under investigation.
my lord, that is right, my lord.
Hmm. The investigation and then 326, that might, we do not know the result thereafter.
My lord,
It might increase the section might also enhance if it is a.
my lord, that part. The only, my lord, the fact, my lord, both party they resolve, my lord, that is only, because in this 326, my lord, in there's series of the case also, this coordinate bench of this honorable, my lord.
Yeah, that is there,
interfere,
even, that
even-
is there. But then here, the case is still under investigation. We
My
need
lord.
to see how it happened.
my lord. That is why, my lord, in when the, my lord, this compounding the scope of the was introduced, my lord, the first parameter, my lord, that was the at earliest, my lord, the settlement, that's also a ground for, my lord. That is why, my lord, they have entered at earliest possible of time.
Now, if such case is allowed, of such petition is allowed, then you see, everybody will assault anybody, and then you see, settle like this.
My lord.
It will be very difficult. In all the cases, not all the cases are similar. In some cases, you say, the person who are subjected, they will face a lot of problem, only with meager compensation,
My lord.
and they'll also be compelled to sign. It's difficult, especially when the case is still under investigation. If it is a minor offense, no problem. We have no problem at all. Okay, yes, possible. I have to point out that This is corresponding section with 326 lordship.
Hmm?
So corresponding section is lordship.
326, that is why I'm saying.
Yes, yes.
Okay, will issue notice?
Yes, lordship.
Call for the record, okay.
Yes.
Heard. Mr. Tita Kong, Land Council for the petitioner. Start.
Thank you. No.
By filing this application under section 528 of Bharatiya Nagarik Suraksha Sanhita 2023, the petitioner prays for quashing of the Duimukh PS case number 87/25, comma, under section 118 within bracket 2, bracket close, BNS 2023. So there is a corresponding GR.
Yes, my lord, GR.
So how it came about?
My lord, it is written there, my lord, page 14, my lord, in the FR itself, they have written. They've entered, my lord, when FR is registered, my lord, along with PS case, they entered in GR, my lord, at page 14, my lord, top, my lord, you see GR 536 of 2025. Already entered, my lord, yeah. Because FR is to be, my lord, forwarded, after forwarding, my lord, the GR entered, my lord. Page 14, my lord, see.
Okay, corresponding to GR case number 536/2025. Arising out of FIR dated 28/6/2025. On the ground that the matter has mutually been settled between the parties. Issue notice, call for the scanned copy of the case diary. It will be case diary. or-
Yes, ma'am, case diary.
Mr. Loilani PP. Since Mr. Loilani PP appeared and accept notice on behalf of the state respondent, no formal notice need be issued. List this matter. When?
19. 19.
19?
Yes, lordship.
Okay, on 19. Okay.
My lord, this matter may be passed over for some time.
Okay. Pass over, why?
I'm for the applicant petitioner.
Hmm?
I'm for the petitioner.
You are for the petitioner.
Yes.
Why it is to be passed over for the time being?
That leading counsel is attending in another court.
Another course. Okay,
Obliged.
time being.
Yeah, please, ma'am.
Yes.
My lord, on the last occasion, my lord was pleased to give a direction to the learned public prosecutor to ascertain whether any medical report has been submitted before the learned judicial magistrate first class, classifying that the alleged accused person is HIV negative.
Yes, what is there any report?
Lordship, with regard to the MLC report, lordship, report is with the trial court, lordship. Trial court written the original copy of this medical report, lordship.
So,
Though I tell you
charge
that-
sheeted already.
No, not charge sheeted, lordship.
Then what is the stage of the in the case status?
No, lordship, another direction was for certain to record the statement of the lordship, the Talapatam lordship, statement of Talapatam lordship, whether he was
Recorded or not?
Recorded lordship.
Recorded.
Yes, lordship, here is.
Record says he was not engaged, Lordship.
Okay, this statement was recorded in the meantime.
Yes,
After,
through video conference.
After, okay. You will never authorized, not even appointed, not even in the contingent also,
Yeah.
not even contract.
No, he was only on the pleasure of the.
volunteered And not given any power, just you wanted to assist and you were just allowed.
If my lord may kindly have page number 26, there are some directions which has been given by the deputy commissioner.
Hmm?
If my lord may peruse page number 26 to 28. Those are the orders of the Deputy Commissioner. My lord, may kindly have page number 26.
Page
26.
Lordship, earlier said the Lordship. Yes, lady, Lordship. Okay.
Page number 26.
What is
This is the order passed by the Deputy Commissioner, my lord. Since he has been denying in the statement under 161. If my lord, I may read. In the public interest, the following officials.
26. Page
My page 26.
26.
26.
Yes.
Order. In the public interest, the following officials are directed to conduct patrolling in the capital region and prevent all kinds of illegal art cutting, illegal dumping of debris on ROW, river, drains, and illegal construction. Number 2, my lord, Humchin Yekal. Now, my lord, he is denying the fact that he has engaged in, my lord. But as per the record, my lord, record says
No, he volunteered. He said that he volunteered. That is why he was allowed to assist.
Maybe.
So in that way.
Maybe, my lord,
So what is this?
prima facie, maybe, my lord, there's a case, my lord, against the alleged accused person. But my grounds before my lord is that, number 1, I'm a HIV positive, my lord.
That report is not yet.
Lordship, with that regard, I personally called the Lordship. He says he is HIV positive, Lordship. But that cannot be a grant for.
The report, the court says that he is negative. You were asked to produce the record,
Yes.
the genuine record, genuine document.
Then Lordship, this
But
medical
that,
report will call
that
from.
cannot be the ground also, that
My lord,
provision
my
is
lord,
there.
and I have just crossed the juvenility, my lord. I'm only 19 years of age, my lord. And even in case of conviction also, my lord, there's always, my lord, admonition under 360, my lord, even in conviction also.
Approach the deputy commissioner yourself. And then
Still, my lord,
you have
I'm
done so many
just
things.
crossed the juvenility.
So many things.
I'm pursuing my studies at first year in Don Bosco College, my lord.
See, it's very dangerous sometimes. Some people need to be actually.
My only concern is that since he has been under
controlled as per
custody.
the rules,
My-
as per the rules, not
Since-
of course beyond the rules.
So prima facie, admittingly, my lord, there seems to be a case, my lord.
Understand.
But my lord, since it has been more than 47 days, my lord, whether a custodial interrogation is necessary at this stage or not.
What is the stage of status of the investigation?
Lordship,
Completed or what?
not completed, Lordship. In the second phase, Lordship, in the CD, second phase, I objected the bail application, Lordship. For fair investigation, Lordship. Last down below, Lordship.
See, the public said, he acted as he is a magistrate when he was not the magistrate, and then the public confidence, now the public confidence upon the magistrate, whosoever comes and on the ground will be, see, the people will disbelieve.
My lord, I totally understand, my lord. That is a subject matter of a trial court, my lord. Now at this
Yes,
stage,
yes,
my
that
lord,
is there.
I am under custody since
That-
last 47 days.
So many things is found out, recovered.
In such
See.
facts and circumstances, my lord, there has been some leniency which has always been shown by the Honorable Supreme Court as well as the coordinate bench of this Honorable Court. On the last occasion, I have placed one authority, my lord. I may be allowed to place one more authority, my lord. On this count, as well as on the ground that he is a fast offender and he has just crossed the juvenility, my lord. My lord allows me, please.
See, the case record doesn't.
My lord, I'll read from para 3. May I read, my lord?
Yes.
Having regard to the peculiar circumstances of the case, given that the petitioner is suffering from HIV and appears to be immunocompromised, this court is of the opinion that the case for grant of bail is made out. In the circumstances, the petitioner shall be enlarged on bail, subject to such terms and conditions imposed by the trial court, my lord. Even the Supreme Court has considering the fact that the alleged accused person has been suffering from HIV positive, my lord. On that ground itself, it has been considered. My lord, the another judgment which has been considered by the coordinate bench of this Honorable Court. If I may read from para 6, my lord. May I read, my lord? I have considered the submission at the bar with circumspection. The health status report of the petitioner clearly reveals that the petitioner is immunocompromised and she is an HIV patient who is also suffering from tuberculosis. She is prone to infection as she is immunocompromised. She is lodged in a jail with several inmates. I have also considered the submission that trial has not commenced. The petitioner was behind bars since so and so. Charge sheet has been laid against the petitioner, but charge has not been framed and the trial is not yet commenced. I have also relied on the decision of the Honorable Supreme Court in Bhavani Singh's case, the earlier case, my lord. It is indeed strict law that in cases involving NDPS Act, especially involving in seizure of commercial quantity of contraband, the rigors of Section 37 are to be complied with. On the other hand, there are indeed provisions of Article 21 of the Constitution of India to say that life and liberty of the person are equally important. Considering all aspects and in the light of the decision of the Honorable Supreme Court in Bhavani Singh's case, I deem it proper to grant bail to the petitioner. The petitioner is enlarged on bail with 1 lakh rupees and 2 local sureties, solely on the ground that, my lord, the petitioner, the alleged accused person is suffering from HIV positive. The same has been considered. Now, my lord, the similar observation has been given by the Honorable Meghalaya High Court, my lord. For the record, I'll just read para 5 only, my lord.
See, this bail was considered after how many days? It's
My lord,
more than a year.
by the court
around
rate
year,
bench.
After around a year.
By the court
There
rate
it
bench.
is where he
My
has
lord,
not yet completed.
but
How
here in
many
this
days?
case, my lord, I have been in custody since last 47 days. I have just
Maybe-
crossed the
maybe-
juvenility, my
maybe
lord.
in this case, they have completed years, almost year.
But considering the
And
nature of,
in the other case, in the other referred case, how many days he was inside? For how many days he was inside the custody?
as of today, my lord, it's 47
No,
days.
no,
my
no.
lord.
So this is 47 years, 47 days.
The
But then in
Supreme
the
Court-
case of the accused person who was granted bail,
By the Honorable
because they
Supreme
were
Court.
granted bail because they have been inside the custody for considerable period of 1 year.
My lord, to
So
my,
then here is the case where he has not yet completed the statutory period also. The case is still under investigation.
but to my limited understanding of law, what is the purpose of keeping in a custody, my
I
lord?
have no idea.
My lord,
Because this is still under
because
investigation.
my limited
If the
understanding, my lord,
investigation has been completed, then the IO will indicate that, no, he is.
my lord, to my limited understanding, the very purpose is that he should face the trial, my lord. And he should not, there should not be a flight risk, my lord.
See, admitted, you yourself has admitted that there is a prima facie case.
Prima facie appears to be, my lord. But the
And
very
then
purpose of
he himself has
investigation.
Admitted, recovered, seized, and everything.
Well,
Under the circumstances, knowing all those facts, and it's still, unless he's.
Yes, Lordship.
Prima facie at this stage, my lord, that can be presumed at this stage that there is prima facie case, my lord. That is a subject matter of trial, my lord. But for the purpose of consideration of bail, my lord,
Yes, yes. That is.
I have placed the ground, my lord. I am HIV positive, my lord. I have just crossed the juvenility, my lord. I am pursuing my studies, studying in first year at Don Bosco College, my lord.
You are the HIV patient, why you had to rush? So,
My lord, I have been, the certificate has been issued by the recognized institute, my lord.
see, recognize, that's what I'm saying.
Well.
You knew it from the very beginning, that
Well.
you are HIV patient.
My lord.
So infected. You had to rush, I'm saying, for the power.
My lord,
And an entire administration has been disturbed. The functioning of the administration because of his
That's-
act. And he, knowing the fact that he is, when that certificate was issued, when he came to know that he is.
my lord, the certificate was issued,
Way back, I think,
my lord,
it's not that he didn't realize.
15 to 2023, certificate was
See,
issued.
he knew it.
Right.
I don't know what was his intention.
But since, my lord, the purpose of investigation, he has been cooperating with the investigation, my lord.
See,
That is,
in
that,
all the cases,
my lord.
after arrest, every accused has to, they are bound to cooperate.
And in that is,
They are
that-
bound to cooperate, everybody cooperates,
my lord.
cooperate. Lakhs of people, lakhs of accused persons, everybody cooperate. It's not that anyone has not cooperated.
My lord,
That exceptional case.
my lord.
So only on the base.
I have
on this
placed,
ground.
my lord, I have placed 2-3 grounds, my lord.
In that ground, if the accused is to be released, then everyone is to be released.
But the very purpose of bail, my lord, is for the purpose of investigation and
See,
whether a
see,
custodial interrogation is
see,
necessary at this stage or not, my
offense-
lord. That has
See
to
the
be.
offense. that affect the society itself. That is why.
Understand.
Otherwise, you see, he's a young person, and then you have a ground for the HIV positive. He can be, of course.
And Lordship,
Should not
there are
be-
37 more tests to be examined, Lordship.
No, that is why I've seen.
Yes.
Investigation and the interrogation should not be in the form of a punitive, my lord.
That is
In that case, my lord,
that
since
is true.
there was
That's
a,
the case, clear case. It's not even a case of doubt.
since there was a
Not even a
direction,
case
my
of
lord,
suspect.
since there was a direction of the
Case of the distrust, the DC himself has stated so
But
many things.
DC has
He
given an
never,
order, my lord.
he's not even a contract, he says.
Yes, that is true that there is no any order of appointment. But since there's a direction given by the deputy commissioner where his name has been reflected, my lord.
He won the trust of the deputy commissioner and what he did.
Well, in that case, my lord, records, since the learned judicial magistrate first class has made an observation in the order that he is HIV negative, my lord, to ascertain that aspect, my lord, at least a direction, my lord, to the learned public prosecutor to
Order is
bring on
already there.
record.
He's yet to produce.
my lord,
The order is already there.
on the next date, it might produce. Because as per the submission of the learned PP, he states that he had telephonic
Only Lordship, only CD was called for, since I already stated the
Let
Lordship.
him be there for 15 more days. Then you are praying, basically you are praying for that.
My lord, since he has made a submission before my lord,
Because it's 15 days, statutory period is 60 days. Now he has been for
my
45.
lord, in this case, I think it would be 90 days, my lord. There's a imprisonment
days?
for life, my lord.
Is it?
Yes, my lord. Since my lord since the learned public prosecutor has made a submission before my lord,
Already there. The learned public prosecutor shall obtain instruction regarding the authenticity of the patient booklet, green book, booklet,
my lord,
as well as the laboratory report of the accused.
on the next date, my lord,
The direction is already there. You just obtain this,
Yes, yes.
issue reminder to the OC or IO of the case to produce this, because this is crucial in the sense because he is praying on this basis. And then on that basis, of course, as per based on the Supreme Court order, in this case, of course, his case can also be considered. But let us see, let us ensure that.
Lordship, the medical
because
report is not with the.
Because the trial
IO.
court below has observed that is negative. Then let us ensure the genuineness of the report. Okay. When the
Lordship, it is from JFC only, Lordship. Monday, Lordship. Next Monday, 11.
no.
on 18, my lord.
Okay, let us fix it on 18.
18.
Then probably he will complete at least 60
More
days.
than 60 days.
Let
Cross
it
60
be
days.
there for some days. Some more days. Okay. Mr. Sitting, Learned Counsel for the petitioner is present. Mr. Loy, Learned PP. This is original.
Yes, Lordship.
Okay. Praise for some more time to obtain instruction regarding the authenticity of the patient booklet, within bracket green booklet, as well as the laboratory report of the accused. To ensure the prayer is allowed. So, on request of the parties, let this matter be listed again on 18 star. I think on which date the updated scanned copy of the case study as well as the report is directed on 28/7/2025 shall be produced. Okay.
Grateful.
Yeah.
Well.
Oh, this is 12. Yes, what is this?
Dedication also.
Yes.
Yes, Your Lordship, I was arrested on 30/12/2024, and as of today, it has been more than 7 months that I've been in custody.
Hmm?
As of today, it has been more than 7 months that I've been in custody.
What is the
Now,
offense?
the facts in this case, Your Honor, is that on 26/12/2024, a missing report was filed by one person called Duimena. Now,
What is the name of the present accused? For
Rahul
whom you are
Amin.
seeking bail?
Rahul Amin.
Rahul Amin.
Yes,
Amin.
yes.
How long you said, how long you have been?
7 months, more than 7 months, 5 days to be precise.
7 months.
Yes. In 5 months,
Okay.
5 days.
So what is the stage of trial?
It is in the stage of evidence, I say.
Hmm?
Stage of evidence.
How many have been recorded?
3. And there are more than 16 witnesses. And one thing, Your Lordship, is that the FSL report is yet to be received.
FSL report probably, if, see, an additional PP, it appears that Rahul, as per the charge sheet, he is not involved, has been thoroughly investigated. Just a minute, just see, page 33.
Yes, Lordship.
The involvement alleged of Rahul, his name is Rahul Ahim.
Yes, Your
So Amin
Rahul
has
Amin.
been thoroughly investigated, and it has been revealed that Rahul Amin has not committed murder, nor has aided him in the commission of crime. Murder, crime. The alleged accused Mofizul has also stated in his statement. The main accused himself has stated that he is not involved in the murder.
Murder is not,
But
yes.
he has helped him bury,
Yes, Lordship.
helped him bury, and to bury the dead body of the deceased. That attracts. Yes, yes.
Their section is attracted, Lordship.
But then he has been there for 7 months. And then he has clearly stated it appeared. Okay. So you have objection?
Lordship, here, Lordship, as per the
Because-
record, Lordship, that statement is already been recorded. Lordship may go to
Nothing
the
is there,
state.
nothing. Has he been implicated
No,
in
Lordship.
the deposition of the prosecution?
Yes, Lordship. Lordship,
Where?
Lordship, in the statement of the accused, Lordship,
Okay.
here he stated that he did not kill Lordship, but he helped him for in the burial process, Lordship.
But the petitioner denies that.
Yes, Lord, that is denied, Lord, that is there, Lordship. In the Lordship, that's why, Lordship, if Lordship deems fit, then he can enlarge on bail, Lordship, because trial is there, Lordship. Trial will proceed.
Okay, Mr. K. Taja, Land Counsel for the petition. Also heard Ms. L. Hage, Land additional people. Earlier, bail was rejected.
Yes.
Okay. This is subsequent bail.
This is first bail before this High Court, Your Lordship. My bail was rejected in the session court.
For praying for release of the accused on bail. So earlier, the bail application moved before, filed before the, which court?
Session court, GPA.
Okay, session court. For release of the accused was rejected. Start. In this para, in this petition, where is the rejection order? What was the observation?
Page number 21 to 27, 25 to 27, Your Lordship. 25 to, page 25 to 27.
This petition, the petitioner contains that the accused is nowhere connected in killing of the deceased lady. And he has no any idea regarding the case. So he was arrested on suspicion. Only on suspicion. Huh? The Learned counsel for the petitioner, referring to the charge sheet filed into the case, brought to the notice of this court, where the eye of the case, while submitting charge sheet, has made the following, made the observation that the involvement of accused Rahul Amin has been thoroughly investigated, and it has been revealed that Rahul Amin has not committed murder, nor has aided the main accused in the commission of crime. Start. The accused, Mofizul Haq, the main accused, the prime accused, Mofizul Haq, has also stated in his police statement that accused Rahul Amin is not involved in the murder of the deceased, but he stated that the accused Rahul Amin assisted him to bury the dead body of the deceased. However, accused Rahul Amin has denied this allegation also. Start. The eye of the case also recorded that in the eye of the case, while just a minute, the eye of the case, in order to verify the denial of the accused, also observe that on the intervening night, the accused Rahul Amin came to the room and they had dinner together. However, after incident, the accused did not return room. The accused did not return room, but the accused, the main accused, Rafizul Haq, did not return, but the accused Rahul Amin has not fled from this station. This indicates that he is not involved into the case. The learned counsel for the petitioner further submits that after framing of charge, the charge was framed against this accused person under which section?
Under all the three sections.
Hmm?
Under all the three sections.
All the three sections?
Yes.
Okay. submits that although a charge was framed against the present accused person under section
103
103
under bracket 1
under bracket 1
slash 238
under bracket
103 under bracket 1
1
slash
slash
238
238
slash
slash
239
239.
BNS.
Okay, but and two prosecution witnesses has already been examined. However, none of the prosecution witnesses has implicated the present accused for his involvement in the case. Stop. The line counsel for the petitioner further submits that the accused has been in the custody for 7 months since his arrest. And he is ready to cooperate the trial of the case. And trial of the case. Stop. Ms. El Hage and additional people fairly submits that in view of the observation made in the charge sheet against the present accused persons and the deposition and non-implication of the accused in the deposition of two prosecution witnesses who have already been examined. So C has no objection if the court is inclined to grant bail to the accused with certain conditions that the accused shall regularly appear the trial court. Start on tab. Heard both the non-counsel for the petitioner parties. I've also perused the records. Start on considering that the accused is not involved in the commission of the alleged offense as per the charge sheet, and also considering that he has already spent 7 months inside the custody, this court is of the opinion that the accused can be granted and enlarged on bail with certain condition to certain condition. Accordingly, accordingly, the bail petition is allowed. The accused is directed to be released on bail on execution of a bail bond of rupees 10,000 with one surety of like amount to the satisfaction of the executing court. To the satisfaction of the sessions court, with further condition that the accused shall cooperate. And so that accused shall regularly appear before the trial court, and that he shall not leave the jurisdiction of the trial court without permission with the above this bail application.
Your Lordship, because I am from Assam.
So you take permission that I'm leaving Assam, I'll regularly attend.
Yes,
That information will be required. Okay? With
Right,
above this bail instance. Okay. Yes.
I know this is also a POXO case, Your Lordship, whether the service is complete or not, that has to be, yes, there has to be a certain.
POXO. So what about the respondent? Not on record.
Whether they have taken steps or not, Your Lordship.
Whether have you taken steps upon the private respondent?
Yes.
It has, not in this manner, my lord. This is not the way. No, you have to take it through a registry. They have taken the step, perhaps it's not permissible.
No. It's a criminal. It has to be through police. Okay, the Land Council for the petitioner.
Steps to
The Land
register.
Council for the petitioner submits that he has taken steps upon the private respondent by the RC service, which according to the Land HLPP, Mr. Ete is not permissible in criminal case. Stop, the Land Council for the petitioner prays for allowing him as a praise for further 1 week time to take steps upon the private respondent by a registered person by through
According to notification 17, my lord, that will suffice. Notification 17, the procedure has been prescribed, your lord, and it has to be taken to registry they have to take steps through jurisdictional PS, and one copy has to be served through registry to the PP, and we will serve the notice to the jurisdictional PS. That is there in the notification 17 of the High Court notification.
17.
Notification 17. Notification
So this-
17.
The direction should be there.
Yes, they have to take steps through
upon the
jurisdictional
respondent.
PS, jurisdictional police
So
station.
the jurisdiction PS.
Yes, and
a copy
step-
of the same.
Yes, and through registry to the
And-
public prosecutor office. Your lordship.
And through the registry,
To public prosecutor office, your lordship.
okay, and through registry.
Yes, your lordship. Otherwise, it has to be bring into the record. So
Okay.
for that, they have to take it to registry, and accordingly, we'll serve it to the jurisdictional PS to the victim, and then we'll receive also record from the police concerned
Okay,
police
to
station.
Take steps upon the respondent. Through the jurisdictional police station.
Yes, as well as through office of PP.
The additional, the PP or additional.
Yes,
additional
office of public prosecutor
And-
routed through registry, madam.
And through the office of the public prosecutor to be routed through the registry.
Yes, your lordship.
Okay,
Yes.
within a week, okay? Okay. The prayer, okay. The prayer is allowed.
My lordship,
Step within a week,
exactly, I have
list this matter. after
submitted this to
3 weeks.
jurisdiction police officer and copy to victim also. I have
For
already
you also, it is beneficial. You
Okay.
learn something, the procedure. Yeah.
Yes.
Okay. So, I think then after, we'll continue at 2.
Yes. Obliged, your lordship.
next date.
नो कॉपी ले जाओ ना रजिस्ट्री में जाओ ठीक है रजिस्ट्री उसको जो है वहां से पूरा बना देगा ना बनाने का रजिस्ट्री
नेक्स्ट डेट को
आफ्टर ए वीक एक वीक का बाद
एक वीक में
हाँ अब ओके ठीक है बीच में सर्विस हो जाने से मेंशन करके उतार दो प्रॉब्लम नहीं हाँ
जल्दी चाहिए PM लोग जल्दी करें
May Lordship, please.
Yes.
As per the order dated on 25/7/2025, the accused person appeared before the Women Police Station Alo, and on the basis of his appearance, his statement has already been recorded and he has been allowed to go on bail. So at this stage, the CD has been called forth. So if CD comes, whether CD has come or not in this case, and no doubt we have met victim as a party to the case, the informant, but this is not a POCSO case. This is a general law will govern, but not governed by the special law, the POCSO. In the case of POCSO, it is a mandatory provision that victim and informant are to be made a party to the case. But whereas it is not come under POCSO, since it is governed by the general law, in that case, it is not mandatory. So my submission is that in support of my allegation, I have filed additional affidavit also. My basic contention is that though FIR have been lodged against me, but it is due to the misunderstanding and misconception of the informant that still I am keeping the relationship. And our relationship is exists. And as per the additional affidavit, I Annex 3, page 31, is the permit order I have taken from the foreign trade officer, take permission and carry the house construction materials and supply to the victim's informant house. Then after that, page 34, this is a Galo Welfare Society census certificate. Here, this is to certify that Jumnia Bagra, under bracket Ruram. I think that she is my wife, but I cannot solemnize the marriage in two occasions. First, I proposed to get married, but they refused. Refused in the sense that their house is not yet completed, construction is not completed. Then again, second proposal was given. Then he said, let my brother to marry first, then I will marry. So whether it will come under the promise to marry.
Okay, let us see if the record has received this.
Your Lordship, they both were in relationship so far this statement is concerned. And there are some differences because the complainant has seen the accused person along with the other girl. They both were in relationship, and in fact, Your Lordship, so far as this statement is concerned, the accused wanted, indeed, he wanted to get married with the girl, Your Lordship.
The present one.
Yes. So, Your Lordship, so far as this allegation is concerned, Your Lordship, these are matter to be investigated. But at this stage, Your Lordship, I've been informed that he is cooperating with the investigation. So, in such cases, Your Lordship, custody interrogation is not deemed required, my lord, in this case, in this nature of case.
So this need to be made absolute.
Yes, and Your Lordship,
he was arrested.
they
Shown
have
arrested.
yes, I have the case there.
He was shown arrested.
Yes, one arrested, my lord.
Okay.
And Your Lordship, the one more aspect is, Your Lordship, inadvertently they have implemented the victim in this case is respondent number 2.
Not
And notices, yes, already been issued. Now, Your Lordship, the new section come that if actually the false promise of marriage, it is not amounting to rape in the new BNS. That section, Your Lordship, doesn't fall under the corresponding section of CRPC 439(1)A, where it speak about, Your Lordship, gang rape, and when there is offense against the minor below 16 years or POCSO. So their imprisonment of the victim is not mandatory in this case. So that may be discharged, my lord. That's it, Your Lordship.
Mr. M. Party, Land Senior Counsel, as he said by Mr. Davi, Land Counsel for the petitioner staff. Also have Mr. Yete, Land Additional PP for the stage respondent staff. By an order dated 25/7/2025, while issuing notice from the petitioner, the applicant was granted interim anticipated bail with certain conditions. Start on. In person to the direction by this court on 25/7/2025. The accused petitioner appeared before the eye of the case. When?
Yes, Your Lordship.
The accused appeared and.
Your Lordship, on 37/25, he was shown arrested, my lord. The arrest memo.
37/20/25.
Yes, Your Lordship.
On his appearance, the accused applicant was arrested in connection with the Itanagar women PS case. Sorry, Alo, women PS case, Alo. And Alo. This is women PS case?
Your Lordship,
Which PS case?
Alo, Your Lordship, WPS Alo.
WPS Alo, number 7/2025. However, he was released on interim anticipated bail on the strength of the order dated 25/7/2025 on execution of a bail bond. The Lanet additional people submit statement. The accused is cooperating with the investigating agency and, the accused, on his appearance, the statement of the accused has been recorded and he is now cooperating with the investigating agency. Therefore, his custodial interrogation is no longer required. Starting entry of the law. And hence, the accused has already been arrested and released on bail. this court is of the opinion that this court just a minute. So this will be disposed of.
Yes,
Okay,
sir.
okay,
Yes,
the
the interim-
bail- the interim anticipatory bail granted to the accused on 25/7/2025 is ever made made absolute, made regularized and made absolute with the same terms and condition, with the further condition that the accused. The conditions are already there.
Yes, Your Lordship.
With the further condition, any other condition you want?
Your Lordship, not required. Only cooperate with the investigation. That will suffice.
Condition
Your
that
Lordship.
the accused shall cooperate with the investigating agency and shall not influence, shall not influence the witness in any manner. With the above, this bail application stand disposal. Okay. Okay,
Obliged, Your Lordship.
return the case study.
Yes, Your Lordship. And Your Lordship, the notice to the respondent number
Okay.
2 may be recalled, Your Lordship.
Okay, in view of the, what is this?
Your Lordship, his implement is not required, Your Lordship,
Okay.
in this case.
The learned ADPP comes that in such case, and the implement of the informant with stroke victim is not necessary. In view of the above, the struck his names, her name shall be struck off only.
Your Lordship, it may be notice, name should be struck and notice may be recalled, Your Lordship. The notice was
In view of
issued.
the above, the name of the respondent number, informant, respondent number 2 is stands struck off, and notice issued
Earlier, Your Lordship.
earlier stands recalled.
Yes, Your
Okay.
Lordship. Deeply obliged.
Yes.
Well, this item 16, item 16 is a very classic case in this court. For the reasons that, my lord, a read petition was filed for revocation of the suspension order of the accused number 1. And thereafter, this honorable court on perusals of certain bail orders have registered this suo motu case. Now, therefore, my lord, today, 48 advocates are appearing in this matter. I am appearing for the accused number 7, my lord, Toy Bagra. Now, my lord, I want to raise one pertinent question of law. Whether this honorable court has a jurisdiction of taking suo motu cognizance and register a criminal case invoking section 528 of the BNSS. Whether, for the reasons that when this High Court exercise its extraordinary jurisdiction, it always must exercise its power under Article 226. 226, my lord, is a vast, it can touch here, there, everywhere, because Lord Chiefs are presiding a equity court, a constitutional court, my lord. Therefore, my lord, kindly allow me to raise the question of maintainability of registering this suo motu case after some time, lord. Because there are
Whether the case was
in this
registered.
case, yes.
Okay, this
The-
is suo motu.
Maintainability, issue of maintainability of registration of the suo motu criminal case invoking section 528 of the BNSS, my lord. Whether it is appropriate for this court to examine the maintainability as to whether it is a criminal petition under 226 or not. That one ground, my lord, I am raising this. This is very important. Now, my lord, kindly see, the accused number 1 has filed a read petition assailing the action of the state government for keeping him under suspension for his detention in this particular case. After 90 days, Ajay Chaudhary's judgment is very clear, my lord. Unless if you don't review the suspension order, if a person is out on bail, his suspension order should be revoked and he should be reinstated in the service.
That
That-
probably is not connected with.
That's why, my lord.
Yes.
But the Germany of this Somoto case is that particular read petition, my lord. From there, this honorable court has taken Somoto cognizance
Yes.
and registered this case under 528 of the BANSS. So therefore, what I am submitting, my lord, is
What is 528?
that's 482, the earlier 482, my lord.
482.
Yes. Whether it under 482 it can register a Somoto case or not. Under what jurisdiction, my lord? This part we will be arguing, my lord. Today I have not prepared well, my lord, but I will come and I will argue this matter. And then other, my lord, my friends, they have to file their objection in this matter, my lord. So therefore, my lord, I respectfully pray.
You have filed objection.
No, many of them
How
are
many
yet
of
to
them have
file.
not yet filed? Because if the objection has already been filed, we can go ahead with the argument and then pass order.
Your
Because
Honor,
only, probably, only the Somoto case, the case was registered only on the ground that no notice was given to the victim
my lord,
before
today,
passing order.
today only I have received appointment order for the respondent number 8.
Respondent number 8 is,
Respondent number
is
8.
also accused.
Yes, he is also accused. So I have to peruse the record and file objection.
Oh,
I am appointed as a legal aid counsel for the respondent number 8.
okay.
Lordship, with regard to item number,
I'll reply.
with,
Yes.
with regard to this item, Lordship, I'm connecting from Guwahati. I, Lordship, have entered appearance on behalf of respondent number 4, 5, and 6. I am
Okay.
representing 3 of the accused person who are standing trial, Lordship, and they are Dulal Bosumatari, Dipali Bosumatari, and Lakshmi Gaur. And with regard to these 3 accused person, we need some time to file our objection, Lordship.
You want also to file objection? Okay.
Yes, yes.
Then let all the respondents and then probably whether the name of all the accused persons who were granted bail bail earlier, do we have all the list of the names?
Yes.
That was called for, my lord.
Okay.
That was called for, my lord, and then
Okay.
service.
On which date it was? Okay.
Service
It was
upon
available.
13 respondents are not completed.
Hmm.
And Madam
I'm
Jaya
responding.
is appearing today for the respondent number 8.
8.
8. Okay.
And,
Then
and
Legal
my
aid.
brother Rajesh is appearing for respondent 4 and 6. 4 and 6.
then let all the respondents file their objection.
Correct.
Okay.
But we will find if they want to.
Then they said he also wanted to file.
Recorded with their respective, your lord, with the accused.
Correct.
Right. That way we'll clarify it now. Hmm.
My lord, I am for the Srimati
Just
Techi
a minute,
Anya
when we
alias
will
Techi
start.
Rina.
Pardon me, sir. I'm parting.
May I please, my lord? My lord, there's one more thing, my lord. Actually, I am appearing on behalf of this Mr. K. Tama and
He's also for accused.
yes, your.
Okay. Hmm.
And there's one more accused is there. His name is Dr. Sendra Ronya.
Okay.
He actually he expired, your honor. And on last occasion in this session court, he was evicted from the case, your honor. Paragraph
Oh, the
8, your honor.
accused expired.
Yes, expired.
Oh.
So, my lord, my humble prayer would be, his name may be, my lord, strike out, my lord.
Lanet Senior Council, Lanet Senior Council, the standing council for Guwahati High Court.
Yes.
May your lord.
Yes.
Your lord, I'm for the respondent number 10.
Okay.
So, my lord, I have filed a written objection. I may
You
grant
want-
liberty
you want
to
to file
withdraw.
objection? Okay.
My lord, I'm representing one more accused, namely Takam Langdeep, my lord.
Let us do one thing.
Okay,
We will indicate the accused person and give our name to the state.
And
Okay?
also
That's fine.
Mr. Deepangi Lane, Emeritus Curie, appearing on behalf of the victim.
Okay.
Okay, and then PP is also there. Okay, Mr.
I am for accused 11.
Okay, just a minute. Deepangi Lane, the council appearing on behalf of the Emeritus, the victim and Mr. Eteha for the state of APM. So, para. The accused, is there any numbering of the accused?
It's a respondent by.
Yes.
Respondent where, do we have the list of the respondents?
Yes, the Lordship can have it from the notice issued by the Deputy Registrar Judicial of the Guwahati High Court. As per that notice, Lordship, we received that notice, Lordship.
Name of the person received. Is this the? Just a minute.
Well, I am for the accused number 1.
Notice of received. So this is.
My lord, may kindly seek on give one of 7 orders.
Or will give my the list of. Yes, that will be.
Okay, then give your name there.
Yes, we are forwarding. When the
Name of the accused,
Yes.
name of the counsels, okay?
Today's stage of proceeding is my lord.
Mr. So-and-so.
Person is to file.
For the,
It's right.
Mr. So-and-so, okay? They'll give the number and record the name of the counsel representing the accused or the respondents, okay?
Lordship, my name may be recorded, Lordship.
Okay, your good name, please.
I am Mr. A.
Right.
Ganguly. A. Ganguly
A-
for respondent number 4, 5, and 6.
A
Ganguly.
Ganguly, for respondent number two is, what is the name?
4, 5, and 6.
4, 5, and 6, okay.
Yes.
Okay, A Ganguly, Lane Council appearing for the respondent number 4, 5, and 6. Okay, for respondent number 1, Mr. Gao is also present.
My lord, I am for the respondent number 1.
You are for respondent number 1, okay. Write your name and for the respondent, okay. And Titi Tara for respondent number 7, okay, 4, 5, and 6. And rest, no respondent number, no number is mentioned, okay. After recording all those, they will give their name.
Yes, ma'am.
The counsel appearing on behalf of the respondent number 4, 5, 6. And who else wanted to file? Okay, Jaya also give, Jaya also, you also want to, okay. You are for respondent number? 8, and you are. I'm for the 2 also, respondent number 2. Okay.
1 also.
4, 5, 6, 8,
And 1 also, my lord.
okay, 1 also. 9. Okay. Wanted to file objection and praise for some time.
I'm also want to file.
Respondent number?
Yes.
You also,
Yes, written objection.
respondent number?
This Takam Bamdi.
Respondent number?
For the members.
This is very confusing, Lord, because.
There is 2 notices, Lord.
Yes.
One is 21/05/2025 and one is 17/06/2025.
Yes.
In
Same person.
No, no.
But the respondent number,
By name.
respondent number.
By name you.
Yes, yes, that's why I.
Takam Lalji, my lord, will.
Okay, Takam,
Yes, Takam Bamdi.
okay, respondent number, okay. You do not know the respondent number,
Yes.
okay. And you are for, Mr.
Yeah, respondent number 3.
3?
3.
Okay, 3 also. And then who expired, you say?
This.
Rojan.
Yes, Lordship. Lordship, Senator Ronya.
Expired. What is this you have
At paragraph 8, Your Honor. He was evicted from the case.
Okay, you are Mr.
T. Lampung.
Mr. T.
Lampung.
appearing on behalf of the respondent number. What was this
National number is not given. Actually, it is not.
name, her name, her who expired, his name?
Dr. Senlar. Dr. Senlar.
Appearing on behalf of Dr.
Senlar Tonya.
Okay. Senlar Ronya.
Yes.
Submit. That the accused has passed away. Well, the sum is that during the pendency of the case, the accused Senlar Ronya passed away. You have any certificate to show? Any
certificate
on
already shown to
37/2025?
District and Session Court.
Okay, 37/2025. And original death certificate has been submitted to the session court. In view of the above, the case against the accused Dr. Senlar Ronya stands abated on his death. Huh? Okay. There prayer for filing sometime we have written, huh? So the prayer is allowed, huh? Okay. So then this will be listed
15 September.
15 September.
I am like for the respondent number 4 and 6 as per the notice dated 21/5/2025.
No, 4 is represented by Mr. Ganguly.
As per the notice 21/5, because I think this names are not given in serial, but
So
as per the
what we'll do this time, you give your name and then the name of the accused. And then if you have been given number earlier, give that also. What we'll do, we'll work out and then make a list of the list, and we'll this time settle the number of the accused person.
Yes,
Number, okay, serial number of the accused person.
Today I think name of the accused
Name of the-
represented by the council.
Council, and if it was earlier reflected that it was accused number or respondent number so and so, reflect that also. We'll clarify it, okay?
We will also
On
file
the-
objection. I will also file objection before.
Okay, and then you're only 4.
Two, for 2 weeks.
Two, namely
Nilam Maha
Neelam Maha
and Vidonime.
and Rime.
Vidonime.
Rime is the respondent number.
Serial number is showing 6 in the notice. And Nilam Manga is shown as 4.
No, serial number 4. Neelam Maha, serial number 6. There are 2 lists, it appears.
Let them give their name to councils, then the paper, and the accused person that they represent. To be simpler for the.
Yes,
We have already.
there is a double number according to him. It appears because respondent number 4 is being represented by Mr. Ganguly also, and then according to him,
Let them give their name and.
you
name of
give the name
person
as well
they
as the serial number, the number respondent number earlier. It was okay. On the
In the
request
meantime,
of-
correction will be given to the registry to the sequentially arrange.
Okay,
as per that manner.
Okay. Since the okay, the registry, the above name of the name of the council representing the accused seems some of the above, some of the name of the accused seems repeated, therefore the registry is directed to write the proper name, proper sequence of the accused.
Right.
Represented, being represented by the councils, okay? On the request of the learned council for the parties, let this matter be listed on 15 September, okay?
Lordship, one small request, Lordship, with regard to the date, Lordship, I am also one of the conducting counsel before the
In the
learned trial
meantime,
court.
in the meantime, all the respondent accused shall file their objection, okay? Yes, what is your request?
Yes, actually, Lordship, I am one of the conducting counsel before the learned trial court. So the next date before the learned trial court is fixed on 8th. Lordship, it would have been convenient on our part if the case is fixed on 9th, Lordship. So that
9th of what?
hearing-
September, no,
9th of
that is not
September.
connected. That is not connected.
Not our power, all the advocates here.
Lordship,
Okay.
Lordship.
Madam, this is about the cancellation of the bail granted to the both the accused persons in.
Yes,
in-
notice was given.
Madam, here is a one typical, as I'm informed, madam. In fact, we taken steps happens to the both the respondents, madam. And the registry refused to issue madam, the notices to the madam, the both the accused person, saying that High Court is already madam, under process for the transfer of the entire thing.
Okay,
So
for the timing, for the timing.
timing. So this is not possible for the councils to take steps, madam. Only that stage, madam, we are pending, madam.
Okay, now,
So therefore, madam, may I pray that, madam?
are you still insisting for the cancellation of bail?
Yes, madam.
Otherwise, whether they have violated any bail condition,
Madam,
whether the accused person has violated any bail conditions?
admittedly, there is no violation, but what we are
Then in
challenging,
that case, you see, that once bail is granted, it's
madam, but we are,
unless they violated
madam, what we are challenging is
the order
madam,
of the,
in-
order of the trial court.
within a period of 2 days from the
Maybe,
death of arrest.
see, that is also, that the bail was granted after consideration of the fact and circumstances of the case only.
In fact,
Maybe
madam,
one day.
it was listed as unlisted on when the bail was granted, madam.
Hmm.
No CD was called for, madam. Nothing was done. Madam, only the request record was produced at the time of
See,
production of the
see,
accused persons, madam.
Unless you make an allegation, then see, the judges or the presiding judge will always pass, it is presumed that you pass only after consideration of the case, entire.
Madam, as I pointed out, Lordship is very correct, madam.
So, with
Madam,
the region. also.
Madam, but in our case, no CD was called for, no case diary was perused, madam. So, madam, it's basing on madam, the production reports, madam, records, basing on that, madam, bail has been granted, madam. Had it been the case that, madam, case diary, entire things, madam,
Have
were
you,
allowed.
have you made any malified intention of?
Madam, in fact,
passing?
malafide part is very difficult to make, madam, and that
Difficult.
aspect we have not.
Then, that is what I am saying. Because you consider, given region probably, while considering the bill, while passing order.
The last occasion, Lordship has pointed out one, the lacunas, wherein, madam, there is no requirement of the custodial integrations of the accused persons. Madam, that is completely wrong and the wrong, madam, the not correct.
No
As per-
interrogation was done in one day, because it was, they were in the custody for one day, and during this period, custodial interrogation was done. See the reflect.
Yes, madam. Madam, this is wrong, madam, the observation. In fact, we have not made, madam, in our, madam, production report, we have clearly stated that, custodial 2 days, madam, the police custody may be given, madam. That was the failure sought for.
See, the investigation with regards to accused person is almost completed, and further accused custody.
This is wrong,
custody
madam.
is not necessary in present case.
This is wrong, madam. That's because in our production report, Malan, nowhere we have stated all these things, Malan.
Okay, so, okay, in any case, you have to give an opportunity to the accused. So let the step be complete. Okay,
Just for a moment, may I, Lordship, may I take your Lordships to the production, Malan, the memo. Malan, this is the production memo, Malan. I'm being done.
it's not available here in the
No,
record.
in fact,
Okay.
Lordship has called for record,
Record is there.
from the, Malan,
Same.
from this CBI.
No, no.
For just a moment, Malan, this
Yes.
is the original record, man. I clicked back. Serial number 8. There is no Malan, the environment that Malan, the interrogation and everything has already been done. Nowhere, Malan, we have stated anything, Malan.
No, it appears that it was done. The interrogation was done where the accused stated, admitted, it appears.
Malan, as per the record, it is
Yeah.
not there, Malan. We have not stated anything, Malan, the interrogation part is over, Malan.
Accepted that on the advantage so and so from accused so and so in different bank account in the name of different persons. See, this has revealed during interrogation.
So many incriminating statement documents, Malan.
Yes, that is there.
Yes.
Then considering that only the bail was granted. After
That is the
consideration.
Malan only, Malan, the
But
enhanced
the-
manner, Malan, at the very initial stage,
Still
Malan.
part it appears that it was complete, interrogation done. And then,
Malan, in such serious nature of offense, Malan, the single day, Malan, the interrogation will be not possible, Malan, as because
I
the.
have no idea, but then it says, the record says, I'm basing on the record. Anyway, but then, let them also file objection if they have any. Okay. In any case, we'll have to give an opportunity to the respondent.
That part, Malan, I mean.
Okay.
Agree. We'll take fresh steps, Malan, even the, Malan, we'll be not able to take fresh steps till, Malan, the 11th of this month, Malan.
Clement of?
11th of this
Oh,
month.
yes, yes, okay.
So, as because.
Mr. M. Kato, non-counsel for a petitioner. Submits that. So you you actually attempted to take steps.
Malan.
Okay.
Malan, my friend, Malan, in this case, Malan, we may be allowed to take steps by tomorrow, Malan.
You said that it was not available, or it's not.
Therefore, Malan, special order, Malan, so as to, Malan, take steps upon the private respondent.
We'll say you take a step within 2 weeks.
Malan,
We'll
2
say,
weeks.
because that will facilitate, because if the entire materials, because now by this week, they are supposed to be there, entire things, except for this court. And then, okay, Mr.
The steps can be taken even-
Non-counsel for petitioner, some said in view of the present situation of shifting of the court, he may be allowed to, or he may be granted 2 weeks time to take fresh steps upon the respondent. They are allowed. Okay, steps upon the respondent by a register post with AD as well as by
Only register postman.
only register post.
Yes.
Okay, within 2 weeks from today, stop. List this matter after 3 weeks, 4 weeks.
No, my lord. It will be two, my lord. After taking steps upon the private respondents, my lord, 1 week time may be granted, my lord. 1 week time may be granted, my lord.
After that?
Yes, my lord.
Then
3 weeks.
if you take steps by tomorrow, if you succeed, it can be, of course. Otherwise, okay, I'll list it after 3 weeks.
Other things that
Cannot be, because you have not yet taken steps. That cannot be fixed.
my lord, in fact, we tried, as I have already pointed out.
We'll say 3 weeks.
Registry.
It will
is
automatically, it will automatically be listed after 3
Yes, my
weeks.
lord. Leave that.
So
This is Lordship listed for
Matrimonial.
mediation also.
So we'll send it to, forward it to mediation. Right? It's a matrimonial
Yes, Lordship.
case. Okay.
Yes.
Right? Explore the possibilities. Okay. You are for respondent.
Respondent.
And who is for the petition?
P. Sharma.
No information.
P. Sharma, then very reflected.
Okay. No one appears on behalf of the petitioner on call. However, Mr.
P. Lona.
Planning Council for the respondent is present. Staff, huh? On page of comma, there is the same order. It will be forwarding will be. What is this matter about otherwise? Matrimonial, but what is the dispute? If it cannot be, no point sending it.
This is Lordship, related to property.
Okay, well, that can be settled. Okay, okay. On perusal of the records, there is on this court find some element of settlement of the matter before the through a mediation staff. Accordingly, let this matter be forwarded to the mediation, to the mediator for mediation, mediator for settlement or mediation staff. The registry is directed to forward this matter to for mediation in the special mediation drive, mediation for the nation, that will be within inverted comma for settlement or mediation. Okay. Registry will say, let us take steps. That includes notice, huh? Okay. Registry shall take steps. Okay. Service is still awaited, but
Yes, sir.
can we, you are from?
Lordship, yes, I'm for 125.
Okay, that is for state.
Yes.
Okay, he was ready. And can it be forwarded to for mediation?
They are
Or have you
coming against
seen? Must have seen. Have you seen?
Yes, Lord.
Can it be forwarded?
No, Your Lordship, we'll take it, instruction.
Okay. Mr. Bolura, we are the Islamic Council for the appellant who is present. And submits that he is ready for mediation. He is ready for settlement or mediation if it is forwarded and stuff. However, Ms. Sangeeta, government advocate, the Learned Council for the state respondent, prays for some time to obtain necessary instruction in this regard. The prayer is allowed. List this matter after 2 weeks. Okay.
Okay.
19 and 20. Oh, they finish.